Welcome to this webcast on privacy, society, and the Internet of Things. My name is Gilad Rosner, and I'm the founder of the Internet of Things Privacy Forum, a nonprofit whose mission is to produce guidance, analysis, and best practices to enable industry and government to reduce privacy risk and innovate responsibly in the world of connected devices. I'll be talking for about 40 minutes, and then we'll open it up for questions. The webcast today will start off with a brief discussion of the nature of the Internet of Things. Then I'll discuss a few of the major meanings of privacy. I'll talk about the differences between privacy and security. Then we'll launch into a discussion of the privacy risks the IoT implies. We'll look at the ways that privacy is protected, and then explore some of the frameworks emerging to address IoT privacy risks specifically. So, what is the Internet of Things? Well, there's no single agreed upon definition, but the term goes back to at least 1999 when Kevin Ashton, then director of the Auto ID Center at MIT, coined the term. The Internet of Things, or IoT, is best thought of as a convergence of several trends, such as widespread and inexpensive telecommunications and local network access, cheap sensors, cheap computing power, miniaturization, location positioning technology like GPS, inexpensive prototyping, and the ubiquity of smartphones as a platform for device interfaces. One term that seems to be interchangeable with the IoT is connected devices, and that's because the focus is on purpose-built devices rather than more generic computers. Your laptop, your desktop, and even your phone now are generic computing platforms. They can do many, many things, most of which were not imagined by their original creators. Devices, in the connected devices sense, refers to objects that are not intended to be full-fledged computers. Fitness and medical wearables, cars, drones, televisions, and toys are built for a relatively narrow set of functions. Certainly they have computing power, and this will only increase over time, but they're things first and computers second. The IoT implies a variety of sensors, including cameras, microphones, accelerometers, and more specific sensors depending on the application. The Internet in the Internet of Things is slightly misleading, as all these devices can't themselves get on the Internet proper, meaning they don't necessarily do TCP/IP, the addressing foundation of the net. But a key characteristic of the IoT is that devices communicate with each other and with host systems. They do so through a variety of standardized networking technologies, including the familiar Bluetooth and the less familiar 6LoWPAN. It's important to note that the IoT, wherever we draw its boundaries, is not revolutionary. It's evolutionary, a continuation of technical trends that begins with the telegraph, through telephony, the advent of computers, wireless telecommunications, electronic sensors, and the microchip. One can make the argument that the Internet of Things doesn't exist as a discrete concept, that it's just things on the net, or things that network. There's a tremendous amount of hype about the IoT, that it's the most important technical evolution in the history of humanity, or the greatest opportunity ever for political change, or the biggest surveillance tool ever devised. This is all over-exaggeration. What I believe is that the Internet of Things is a reflection point, an opportunity to take stock. There are many possible reasons why the IoT has been both given a name and captured the attention of journalists, academics, policymakers, and the public. Partly our interests are cultivated by commercial companies looking for the next marketing trend. Another part is journalists smelling a story. Policymakers sense the economic aspects of the appearance of connected devices and want to associate themselves with it. Many of us like gadgets and science fiction becoming reality. But I believe there's also a sense of vulnerability, an awareness that change is afoot. Part of the goal for this webcast is to explore that vulnerability, to better understand why we may feel a bit hesitant to embrace all of the new technologies the Internet of Things portends. The commercial Internet came into being a little over 20 years ago, and that period has been marked by incredibly swift change. Depending on how you count them, estimates now are that there are more things on the net than people. If indeed networked consumer and industrial devices are a next wave of technological evolution, this is an excellent time to stop and reflect. If these last 20 years of Internet development has been a mixed bag of beneficial technology and an uncomfortable exposure of our informational lives, then let us examine our values, norms, and wishes for how we want data about us to be treated as we look forward to the next 20 years. So what are the privacy challenges of the Internet of Things? Well, before we dive into that, let's back up and ask, what do we mean by privacy? Much like the problem of saying the IoT and then assuming everyone knows what we're talking about, the term privacy means very different things to people. This is true among experts, practitioners, and scholars as much as it is among society at large. Privacy is a concept in disarray, observes law professor Dan Solov. It's too complicated a concept to be boiled down to a single essence. Oftentimes, people equate privacy with secrecy, but keeping information secret from others is only one small piece of what privacy means. Innumerable books and articles have been written on the meaning of privacy, so there's no way that this brief webcast could comprehensively cover the topic, but it'll help us to have, if not a single working definition, an initial discussion of the key elements that contribute to the family of privacy concepts. In 1890, two American lawyers conceived of a right to be let alone. This begins the privacy legal discussion in the US and is often referred to in European discussions of privacy as well. Later, in 1967, privacy scholar Alan Weston identified four basic states of privacy: solitude, which is physical separation from others; intimacy, a close, relaxed, and frank relationship between two or more individuals that can arise from seclusion; anonymity, which is freedom from identification and surveillance in public places; and reserve, the creation of a psychological barrier against unwanted intrusion. Weston wrote that privacy is the claim of individuals, groups, or institutions to determine for themselves when, how, and to what extent information about them is communicated to others. This idea also appears in European conceptions of privacy. In 1983, for example, a German constitutional court articulated a right of informational self-determination, which included the authority of the individual to decide for himself when and within what limits information about his private life should be communicated to others. In Europe, privacy is conceived of as a fundamental right that people are born with. European policies mainly use the term data protection rather than privacy, and while they're not exactly the same, I'll be using them more or less interchangeably. In the US, privacy is not exactly a fundamental right as in Europe, though some US states feature a right to privacy in their state constitutions. Mainly, privacy in the US is protected by a variety of laws and court decisions. In the member states of Europe, protection for personal data is governed by an omnibus rule, meaning that it covers all definitions of what personal data could be. The US is said to have a sectoral treatment of personal data privacy. Different laws cover different types of private information, such as medical data, student data, data held by the government, and even videotape rentals. Whether one system is better than the other is a matter of ongoing debate. In 1960, an American law scholar distilled four types of harmful activities that privacy rights addressed: intrusion upon someone's seclusion or solitude or into her private affairs; public disclosure of embarrassing private facts; publicity, which places someone in a false light; and appropriation of someone's name or likeness for gain without her permission. This conception of privacy is, by design, focused on harms that can befall someone, thereby giving courts a basis from which to redress them. But as the earlier descriptions show, conceiving of privacy exclusively from the perspective of harms is too narrow. Technologically, the world is nothing like 1960. So in 2014, President Obama's Council of Advisors on Science and Technology wrote a report on big data and privacy to update our understanding about how new technologies affect the privacy landscape. They augmented the list of four privacy harms to reflect more modern values and concerns: invasion of private communications, invasion of privacy in a person's virtual home, i.e. the cloud, public disclosure of inferred private facts, tracking, stalking, and violations of locational privacy, harms arising from false conclusions about individuals based on personal profiles from big data analytics, and foreclosure of individual autonomy or self-determination. Thinking of privacy harms tends to focus discussion on individuals. Privacy, however, must be discussed also in terms of society. It's argued that privacy is vital for the functioning of society and democracy. In 1980, an Israeli law scholar named Ruth Gavison wrote, "Privacy is essential to democratic government because it fosters and encourages the moral autonomy of the citizen, a central requirement of democracy. In this way, privacy is constitutive of society. It's integrally tied to its health. For example, freedom of expression is often seen as one of the most important pillars of liberal democracies. This means the protection of both popular and unpopular speech, commonly accepted ideas and dissent, agreement and debate. Privacy acts as a shield for unpopular speech. A U.S. court case in 1995 put this point succinctly. Protections for anonymous speech are vital to democratic discourse. Allowing dissenters to shield their identity frees them to express critical minority views. Anonymity is a shield from the tyranny of the majority. It thus exemplifies the purpose behind the Bill of Rights and of the First Amendment in particular, to protect unpopular individuals from retaliation at the hand of an intolerant society. A lot of the modern discussion of privacy in the U.S. revolves around the concept of the reasonable expectation of privacy. In other words, when a person reasonably expects that their communications or actions can be thought of as occurring in a private context. However, the problem with this standard is that with so much invisible monitoring of us going on, such as the metadata logs of our phone calls, emails flowing through social media sites, data collected by private video cameras, data brokers selling information about us, and televisions which may or may not be listening, what should we reasonably expect? Many people, quite reasonably, believe that they have very little privacy left. And yet, if we believe that things like solitude, intimacy, seclusion, anonymity, and respect for our feelings of vulnerability are values worth preserving, and that our electronic selves are deserving of the same protections as our physical selves, then the reasonable expectation of privacy is a weak and porous standard to rely upon. Privacy is not the law. It's not simply the protection of data at rest or data in motion. Nor is it just a concept of the fair treatment of people's information. It's a shifting conversation about values and norms with regard to the flow of information, and information is related to power. Power that we can exercise and power that can be exercised against us. Laws and rules enact the values and norms we prize and help us to shape the society we want to live in. This means, however, that the current picture of privacy rules is not the only way to protect it. So, what's the relationship between privacy and security? Oftentimes, commentators and others, let me just get that slide going. Oftentimes, commentators and others conflate the domains of privacy and security, but they are not the same thing. They overlap. Privacy is reliant on security, but they're separate topics. Let's take a look at a definition of security from a U.S. federal law. Information security means protecting information and information systems from unauthorized access, use, disclosure, disruption, modification, or destruction in order to provide integrity, which is guarding against improper modification or destruction of data, confidentiality, which is ensuring only the correct authorized party gets access to systems, and availability, making sure that the system can be accessed when called for. Now, while one of these, confidentiality, has a direct relationship with privacy, you can see with this definition that security has to do with making sure a system does what it's designed to do and can be affected only by the right authorized people. Compare this to the discussion that we just had about privacy, and you can see that security covers a much narrower set of concerns. A good example is the news last year that hackers were able to remotely shut off the engine and trigger the brakes of a Jeep while it was driving. This is a security concern. Wondering about who gets to see all the data that the Jeep's black box records is a privacy concern. It's related to access and information flows. Now that we've briefly explored the nature of the IoT and what we mean by privacy, we can start to look at some of the privacy risks that connected devices imply. Perhaps the chief risk, born of a world of sensing connected devices, is the amplified monitoring of human activity. Indeed, context awareness through enhanced audio, video, location, and other forms of detection is touted as a central value of the Internet of Things. There's no doubt that important and helpful new services will be enabled by such detection, but the privacy implication is clear. You will be under observation by your machines, and ones you do not control in your environment. Vint Cerf, often described as one of the fathers of the Internet, said in 2014, "Continuous monitoring is likely to be a powerful element in our lives." Certainly this exists in the world today. Public CCTV, private security cameras, MAC address detection, location data capture from phones, license plate readers. The human world is highly monitored, so the issue is one of scale. It can certainly be argued that such monitoring is a condition of modern life. that observation by both the state and the private sector are core features of the social landscape. This, then, is a central reason why the right to be left alone is a prominent value within privacy discourse. When those two American lawyers, Warren and Brandeis, proposed this right in 1890, it was in response to the appearance of a new technology, photography. They saw the potential for photography to intrude upon private spaces and broadcast what was captured to ever-widening audiences through newspapers. The discussion of privacy and the IoT is no different. It's not the Internet of Things that raises hackles. It's the intimacy of things. Warren and Brandeis worried about photographers snapping pictures through bedroom windows. A modern version of this is the bathroom scale and your Fitbit broadcasting your weight and lack of exercise regime to an audience larger than you may have intended. The encroachment of sensing technology into more and more intimate spaces contributes to the collective sense of vulnerability the IoT engenders. A direct result of enhanced monitoring is greater ease in tracking people's movements. That is, more devices, and therefore more organizations and systems, will know where you are, where you've been, and increasingly where you're going next. Location privacy has been eroded for many years now, but that fact alone should not inure us to the harms that implies. In 2010, the Electronic Frontier Foundation published a series of answerable questions implied by devices and organizations knowing your whereabouts. Did you go to an anti-war rally on Tuesday? A small meeting to plan the rally the week before? Did you walk into an abortion clinic? Did you see an AIDS counselor? Have you been checking into a motel at lunchtimes? Did you skip lunch to pitch a new invention to a VC? Were you the person who anonymously tipped off safety regulators about the rusty machines? Which church do you attend? Which mosque? Which gay bars? The loss of location privacy was tremendously enhanced by GPS-enabled mobile phones, but that doesn't mean more devices tracking your movements are a non-issue. Not only will more devices track you in your home and private spaces, the questions above imply much greater tracking in public. While public spaces have often been seen to carry no expectation of privacy, a closer examination of that idea shows it's not so clear-cut. Consider a conversation held between two people at a restaurant at low volume, or a phone call about a sick family member while someone is on a train. Should your wearable device manufacturer know if and when you go to church, or to an STD clinic, or to hear a speech by an unpopular political candidate? Modern privacy thinking discards the easy public-private dichotomy in favor of a more contextual, fluid view. Fairness, justice, and senses of vulnerability contribute to the norms of society. Even if the law does not disallow the collection of all this information about you, that does not invalidate your discomfort. Discussion of the interplay between technology and intimacy are a vital component of how the two co-evolve. The introduction of more sensing devices into the human environment raises questions of consent. While individuals can consent to devices they purchase and install, what of the people who enter spaces monitored by connected devices who don't even know that they're there? Consider a guest in your home. Will she know that the TV is always listening? Or what of a health device in the bathroom? These questions may not directly implicate policy choices, but they do implicate design choices. There's an inevitability to the IoT. That is, the evolution of products will, in some cases, invariably introduce enhanced monitoring and connectivity feature functions. Consider the car. New models are being introduced with integrated location tracking, network connectivity to the car's subsystems, and even the ability for drivers to tweet. As more vehicles incorporate IoT-like features, will drivers be able to turn them off? That is, when someone buys a new or used car and does not wish to have her movements tracked when driving, is there a big off switch for the data collection? If the current take-it-or-leave-it attitude towards consent and data use is imported from the web into the connected devices, will car buyers find themselves being told, you can't prevent the car and therefore the dealer, manufacturer, and others from monitoring you. If you don't like it, don't buy the car. This is the world of no opt-out, and it diminishes the ability to withhold consent. With regard to mobile devices and the IoT, a European data protection watchdog has said that users should have the ability to continuously withdraw their consent without having to exit a service. In the case of a car, whose obvious main purpose is driving, strong support of user choices means an ability to kill all non-essential data gathering. In the United States, traditional medical information, like lab results, doctor's notes, medical records, drug prescriptions, etc., are held to strict standards of disclosure. The current policy regime governing that disclosure is called the Health Insurance Portability and Accountability Act, or HIPAA, and it specifies rules for who gets to see your medical information and the security of its transport. In Europe, medical data is deemed to be sensitive personal data and is subject to heightened regulatory requirements as well. Moreover, there are cultural prohibitions and discomforts around medical information that people feel in varying degrees. The reasons for such privileged treatment of medical information are an awareness that people will not disclose critical information to doctors if they fear a lack of privacy, leading to untreated illnesses, stigmatization, loss of job, or other harms from revelation of medical condition or disease, challenges to dignity, a baseline belief that people have civil rights to control the flow of information about their physical and mental health. The Internet of Things muddles the world of medical data. Health and fitness-oriented consumer IoT devices introduce new technologies, new data gathering techniques, new information flows, and new stakeholders. At the same time, they break down the traditional categories of medical information regulation. What is a healthcare provider, a lab, a patient, a medical device, an insurance company? When non-medical fitness wearables gather heart rate, sleep pattern and times, blood pressure, oxygenation, and other vital signs, it becomes hard to see how they differ from medical devices that trigger heightened quality, security, and privacy protections. The difference is one of use. If a doctor is to rely upon the data, it causes a shift in product safety and reliability. If it's only you, the device manufacturers do not have incentive to pay for the higher regulatory burden. This, of course, also allows the device to remain at a consumer goods price rather than a far more expensive medical device price. The privacy questions at issue are, who can see my health information, and what uses can it be put to? HIPAA specifies a number of uses and, importantly, prohibitions of use of medical data. For example, no marketing to a person without expressly getting permission. Wearables that don't trigger HIPAA, however, are not subject to use prohibitions. One theme that emerges from the risks we've been discussing is the blending of data from different sources and different facets of people's lives. From enhanced monitoring, we get the concept of sensor fusion. Legal scholar Scott Pevitt writes, just as two eyes generate depth of field that neither eye alone can perceive, two Internet of Things sensors may reveal unexpected inferences. Sensor fusion means that on the Internet of Things, everything may reveal everything, meaning each type of consumer sensor can be used for many purposes beyond that particular sensor's original use or context, particularly in combination with data from other Internet of Things devices. The implication of sensor fusion and the trend towards sharing data across multiple contexts, health, employment, financial, home life, etc., is the further breaking down of informational contexts. Privacy scholar Helen Nissenbaum and her colleagues have spent more than a decade refining the theory of contextual integrity, which attempts to explain why people feel privacy violations. The theory focuses on the informational norms of appropriateness and transmission, which information is appropriate to reveal in a given context, and the norms that govern the transfer of information from one party to another. It's appropriate for you to reveal medical information to your doctor, but not your financial situation, and the reverse is true with your accountant. As to transmission, it's right for a doctor to send your medical information to labs and your insurance company, but not to law enforcement. When these norms are violated and context boundaries are unexpectedly crossed, people experience it as a violation of their privacy. Context sensitivity like this exists within a variety of laws and policies. In the United States, a law called the Fair Credit Reporting Act specifies that credit reports collected by credit reference agencies, such as Experian and Equifax, may only be used when making decisions about offering someone credit, employment, underwriting insurance, and license eligibility. The original intent behind whitelisting these uses was to preserve the appropriate use of credit reports and support privacy. Modern discussions of privacy recognize that context matters, where information is gathered, which information is gathered, and whom it is shared with. In the case of medical information or credit reports, norms of appropriateness and transmission have been at least minimally addressed within the law, but there remains a huge amount of data collected about us that policy has yet to address. In 2012, the White House released a Consumer Privacy Bill of Rights. which states, consumers have a right to expect that companies will collect, use, and disclose personal data in ways that are consistent with the context in which consumers provide the data. Companies should limit their use and disclosure of personal data to those purposes that are consistent with both the relationship they have with consumers and the context in which consumers originally disclosed the data. With regard to connected devices, contextual questions arise, such as, how do I ensure that my employer does not see my health information from my wearables if I don't want them to? If I share a connected device with someone, how do I ensure that my use of it can be kept private? What rules are in place regarding data collected in my home and sharing it with my insurance company? What data from my car can my insurer get? Who can see when I'm home or what activities I'm engaging in? What rights do I have regarding the privacy of my whereabouts? Since the 2013 revelations of NSA whistleblower Edward Snowden, the public has been made aware of an exceedingly broad and far-ranging surveillance agenda by governments around the world. One critical component of this agenda has been the passage of personal data collected by private companies to the government through both front and backdoor means, direct legal requests, and, according to investigative reporters, spying inside the companies. The relevance to the IoT is that the coming wave of devices is anticipated to collect tremendous amounts of personal, intimate data. One possible conclusion is that some of this data will fall into the surveillance dragnet. In fact, 1 week ago today, James Clapper, the U.S. Director of National Intelligence, testified to Congress. In the future, intelligence services might use the Internet of Things for identification, surveillance, monitoring, location tracking, and targeting for recruitment, or to gain access to networks or user credentials. The goals and methods of national intelligence and the values of privacy have often been in the tug of war. If a free society means anything, it means not blindly accepting the narrative of a security agenda. That said, intelligence and law enforcement are vital elements of a safe society, so it also means acknowledging the need for tools and methods of responsible policing and intelligence gathering. Part of the reason to discuss the values of privacy is to understand how they compete, overlap with, and support other values, such as safety and order. Privacy protection is accomplished through various mechanisms. So before reviewing the different frameworks that can be brought to bear on the privacy challenges of the IoT, it's helpful to review the key methods of privacy preservation. Note that these categories often overlap and reinforce one another in a regulatory mix. Law and policy, this is likely the most familiar mechanism. It includes things such as HIPAA for medical information, FERPA for student information, the EU Data Protection Directive, the UK Data Protection Act, the US Privacy Act of 1974, and other formal legal instruments. It includes torts, court decisions, administrative policy, government contracting rules, and rules laid down by regulatory agencies. The next is contract. Privacy policies and terms and conditions are the most visible mechanisms of privacy management. They're agreements between an organization and a data source, that is, a human being. They're not protection methods per se in that they're not by nature designed to protect people's interests or rights. They're neutral containers for rules about how an organization will behave. They can be written with a bias towards ethical treatment of people, or can be written so as to privilege an organization's wishes. Contracts are constrained by many factors, including laws, court decisions, and existing business arrangements. In the US, if a company publishes a privacy policy, the Federal Trade Commission views it as a promise to customers. If they break that promise and do things with data they said they wouldn't, the FTC may investigate them. This is one way in which contracts can become protective instruments. Next is market controls. Privacy can be protected by the behavior of the market. That is, the market rewards and punishes based on the preferences of consumers and buyers. A business may do something completely legal and, to them, completely normal. However, if the buying public does not like it for some reason, it may punish the business by refusing to buy, or worse. A useful example is Samsung's sale of a television last year that could accept voice commands. Its privacy policy said that the TV could pick up bits of personal communication spoken near it. This caused a spate of Big Brother comparisons in the media, injuring Samsung's brand a little, which could potentially harm sales. Market punishment through violation of consumer expectations, norms, and wishes is a core mechanism for an economically driven vision of privacy preservation. One of the more common methods of privacy protection, self-regulation, as the name implies, means that businesses govern their own behavior with regard to privacy. The vehicles for self-regulation are agreed upon codes of conduct, best practices, industry-based licensure, certification marks, and other forms of regulating behavior where sanctions come from industry or the market and not from government. Examples include the Direct Marketing Association, the Network Advertising Initiative, and the UK's Advertising Standards Authority. When governments become involved with self-regulatory efforts by, for example, taking on some of the tasks of managing the regulation or its sanctioning power, it's called co-regulation. A wide variety of certification schemes and privacy seals exist. Mandatory certification in the privacy realm is rare, so when businesses apply to become certified or to obtain the right to display a seal, it's a voluntary choice to signal to various audiences their adherence to a set of guidelines or principles. When doing so, the two key methods of attesting to adherence are self-certification, where a business assesses itself for conformance, and third-party certification, where a person from outside an organization assesses them for conformance. Examples of privacy certification and seals are Trustee and the Better Business Bureau Online for US websites, Europrise for Europe, and the ESRB Privacy Seal for video games and mobile apps. Companies, trade associations, nonprofits, governments, and others publish sets of best practices for data handling and privacy for various segments of the market. This is, of course, subjective, but when done well, are created with the help of experts who balance practicality, realism, and feasibility with broad goals and ethics. When done poorly, best practices merely reinforce existing business practices or offer infeasible suggestions. Best practices are plentiful, published by well-known organizations like the American Bar Association, the International Association of Privacy Practitioners, the U.S. Department of Homeland Security, and the UK Information Commissioner. Best practices are almost always voluntary. Human behavior is guided by many things, internal and external. When behaviors become more or less generally accepted within a group, they are called norms. Some are widely accepted. Murder is evil and forbidden, for example. Others less so, such as the acceptability of talking during a movie. Norms are one of the central constitutive forces of society, given voice through a variety of mechanisms, and they play a central role in the issue of privacy. Consider the prohibition of surveillance in bathrooms, which is, whether explicitly banned by laws or not, this privacy norm powerfully constrains behavior in most of America and Europe. But what about eavesdropping in public? Here we see another norm that is less widely accepted. It's fine for some and impermissible for others. With regard to the Internet of Things, billions of connected devices appearing in public and burrowing into intimate personal spaces encourages us to reflect on our privacy norms. Feelings such as vulnerability, exposure, or lack of control over data about us are fundamental components of those norms, and they contribute to the social dialogue that ultimately informs the regulatory methods I've been describing. Is it acceptable for children's toys to listen to what they say and then transmit it unencrypted over to a company's servers? Should employers be able to get access to your location history when you're off the clock? Should devices in your home be able to determine who your guests are and the times they arrive and leave? People's answers to these will almost certainly vary, and the answers are an important part of the discussion that informs regulation. Technology is the final method. Privacy is often protected through technical means. Just as the locks on your door and windows offer some protection from burglary, software and hardware are used to prevent theft or unauthorized access to private data. By now, most people have heard of encryption, which is the use of complex math to scramble data. Only with the right key can it be unscrambled. But even the use of passwords is an example of technical means of protection. Using technology to keep data private illustrates a critical point. Privacy costs money. Designing, building, buying, learning to use, and implementing any technology costs organizations money. Systems that are designed with strong mechanisms to protect the privacy of data will cost more than systems with weak ones. This is a key issue in the Internet of Things, which, at the consumer level, will be built to be cost-conscious. Further, companies that are good at making things, like cars and wearables and TVs, may not be good at security and privacy. Encryption and other complicated methods require specialized know-how and investment. That said, using technology to preserve privacy versus the social methods of laws, contracts, markets, and norms is one of the most important tools available. Consider again the example of locks on your door. You can rely on people not to break in because of the threat of arrest and because such behavior is socially unacceptable, but a piece of metal that prevents your door from opening is still an excellent strategy. Now that we've surveyed definitions of privacy, reviewed some of the privacy risks of a world of connected devices, and discussed the mechanisms of privacy protection, let's take a look at some of the ideas and solutions that have appeared to manage the privacy risks. This is not an exhaustive list, but it's a good introduction to different privacy frameworks that are relevant to the Internet of Things. The first place to start is the law. As we discussed earlier, this is the most coercive method of protecting privacy. That said, it's also one of the slowest to come into being. And with technology evolution moving so quickly, law and regulation are sometimes too coarse to be effective. Still, a number of regulatory suggestions have surfaced. Most of what follows are based on the work of legal scholar Scott Peppett. Expansion of personally identifiable data to include IoT sensor data. This is applicable more to US than Europe. Currently, many US states do not include biometric or other sensor-derived information as personally identifiable. Changing the statutes to include sensor-derived attributes as personal data will have a positive effect on privacy laws generally. It could also force companies to treat sensor data more securely. Data breach notification. Forcing companies to disclose to the public when they've had a breach is a powerful sanction mechanism. Changing the definition of personal data to include IoT sensor data, plus changing the language of data breach notification laws could help shape company behavior towards stricter, more secure practices. As I mentioned earlier with the Fair Credit Reporting Act, laws can be crafted to prohibit certain kinds of data use. More of these use regulations could come into existence, preventing, for example, employers from being able to demand access to fitness data, or insurers from being able to demand data generated by devices in the home, or for IoT sensor data to be available for credit decisions. In the mid-2000s, the European Commission funded a great deal of research into the IoT, though much of this work was focused on RFID-based technologies. Out of this research came the belief that people have a right to disconnect from their networked environment, and therefore be able to deactivate the tracking functions of their RFID devices. A French Internet expert named Bernard Benamou coined the idea of the right to the silence of the chips to capture this belief. More still than with the Internet of Machines, he wrote, it will be necessary that the Internet of Things will be under the control of citizens. They must be able to control the way in which their personal data are used and even the way in which these chips can be deactivated. So in the future, citizens will have to intervene in the architecture of these systems in order to enjoy a new kind of freedom, the silence of the chips. The most common example for the expression of this right was in the retail sector. If a person bought goods with embedded RFID tags, the principle of the silence of the chips would ensure that consumers could kill the tags temporarily or permanently so that they could not be tracked outside the store. An updated version of this right could be formulated as a do not collect feature added to devices, where users could simply blind all of the sensors in a device. When Europe enacted its Data Protection Directive in 1995, it also created a watchdog group called the Article 29 Working Party. This independent group keeps an eye on data protection and privacy issues across all the European member states, publishing advice and proposing guidelines as new technology develops. In their 2014 opinion on the Internet of Things, they proposed a variety of recommendations. Believing that organizations mainly need aggregate data, the group states that raw data should be deleted as soon as the necessary data has been extracted, and that developers who do not need raw data should be prevented from seeing it. The transport of raw data from the device should be minimized as much as possible. If a user withdraws his or her consent, device manufacturers should be able to communicate that fact with all other concerned stakeholders. IoT devices should offer a do not collect option to schedule or quickly disable sensors, similar to a do not disturb feature on mobile phones and the silencing of the chips we just discussed. Devices should be able to disable their own wireless interfaces when not in use, or use random identifiers to prevent location tracking via persistent IDs. Users should be given a friendly interface to be able to access the aggregate or raw data a device or service stores. Devices should have settings to be able to distinguish between different people using it so that one user cannot learn about another's activities. Applications and devices should periodically notify users when they're recording data, and information published to social media platforms should, by default, not be public nor indexed by social media or search engines. Next is the Online Trust Alliance, a nonprofit industry group focused on consumer trust and online brand reputation, which has developed a set of best practices that they intend to broaden into a certification program. Covering the domains of wearables and consumer devices in the home, the OTA's trust framework specifies security practices for authentication and data transport, requires data breach responses and the disclosure of data retention policies, and mandates user notification when devices connect to other entities. In November of 2014, a pair of car manufacturing trade bodies released a set of privacy principles for vehicle technologies and services. Modeled largely on the White House's Consumer Privacy Bill of Rights, the automakers' privacy principles are certainly a step in the right direction, calling for transparency, choice, respect for context, data minimization, and accountability. Members of the two organizations that adopt the principles, which are by no means mandatory, commit to obtaining affirmative consent to use or share geolocation, biometrics, or driver behavior information. Such consent is not required, though, for internal research or product development, nor is consent needed to collect the information in the first place. One could reasonably assert that location, biometrics, and driver behavior are not necessary to the basic functioning of a car, so there's an argument that there should be an option to disable most or all of these monitoring functions should a driver wish to. The automakers' principles do not include such a provision. The field of identity management, or IDM, is concerned with authentication, attributes, and credentials. In other words, methods of identification and access. Not only is this domain important for engineering-level concerns about how devices identify and connect to one another, but it also provides a framework and language for privacy design considerations. For many years, identity practices have been converging around what's called federated identity. In this model, people use a single sign-on to access multiple disparate resources. Facebook logins to access news sites, university logins to access academic publishers, Gmail logins to access other Google functions, and national IDs to log into government websites, for example. Using such single sign-ons means there's always someone looking over your shoulder online, unless the system is designed specifically not to. 15 years of IDM development and the awareness of its privacy challenges have yielded several strategies to mitigate them. For the purposes of the Internet of Things, two key concepts emerge. The first is unlinkability. This is the intentional separation of data events and their sources, breaking the links between users and where they go online. In the IDM world, this means designing systems so that one website does not know you're using another website, even though you're using the same login. In the IoT context, the analogy would be your bathroom scale does not need to know where you drive, or your fitness band does not need to know which websites you visit. There are certainly advantages to the commingling of data from different contexts, and many people will feel comfortable in it happening automatically. The point is for there to be options for those who do not. Therefore, there's a design imperative for IoT devices to not share cross-contextual data without explicit user consent, and for defaults to be set to opt-in to sharing rather than opt-out. The second concept from identity management is unobservability. IDM systems can be built to be blind to the activities that occur within them. People can use credentials and log into various websites, and the plumbing of the credential system is unaware of what goes on. This same design principle can be applied to the various intermediaries, transport subsystems, and middle layers that make up the IoT ecosystem's connective tissue of communications. A privacy impact assessment, or PIA, is a systematic process to evaluate the impact and risks of collecting, using, and disseminating personally identifiable information in a product, service, or system. The goal is to identify privacy risks, ensure compliance with national and local laws, contractual requirements, or company policy, and to put risk mitigation strategies in place. One privacy scholar writes that a PIA anticipates problems, seeking to prevent rather than put out fires. As such, a PIA is an integral part of the planning and development of a new product, service, or system, rather than an afterthought. One expert observes that PIAs analyze risk from the perspective of the data subject and are complementary to security risk assessments, which are done from the perspective of the organization. A security risk assessment may conclude the loss of 10,000 customer records is an acceptable risk for the organization, but the PIA will consider the impact on the affected individuals. A PIA is a flexible instrument. It can be configured to meet a variety of needs, policies, and regulations. This slide shows some of the basic elements it can include. While PIAs have traditionally been used by government agencies, they have clear and direct application in the commercial sphere. Whether a PIA meets the letter of the law and no more, or if it goes far beyond it, incorporating broad ethical concerns and sensitivities for users, a PIA can help organizations get a better sense of the personal data it handles, the associated risks, and how to manage issues before disaster strikes. Well, that takes us to the end of this brief survey of the IoT, privacy, and some of the frameworks emerging to address the potential privacy risks of connected devices. If there's one thing I want you to take away from this webcast, it's this. Strong mechanisms to protect privacy are a sign of a healthy democratic society. And while privacy protection costs money to build into systems, this does not stifle innovation. For those of you who feel vulnerable because of the pace of technology, you're not alone. The Internet of Things heralds a qualitative shift in the amount of data collected about people. Privacy enables responsible innovation. As we introduce more cameras, microphones, and biometric sensors into our personal and public spaces, we'll need better rules and tools, institutional controls, incentives, and dialogue to shape who gets to use what they see and hear. Now is an excellent time to revisit the hard questions about how we regulate the flow of information and shape our informational lives. Thank you very much for listening. I'd be very happy to take some of your questions now. Okay, we have some questions in the Q&A box here. So, let's see. I see a question here that says, how can I protect? Okay, this is not a question I think I can answer. This is asking specifically, there's a question here asking specifically about how to protect energy use analysis. That's a bit beyond me, so I'm going to have to jump on to the next question. I see here a question, have you come across a US equivalent to iRights in the UK to review online policy for the perspective of young people? Thank you, Julie. I am actually unfamiliar with iRights. If you write into the question box what you mean, then I will try to answer it as well. Another question here is, how can this be applied by individuals? How can I know what my new IoT device shares with and whom? So this is a great question. I get this a lot, and it's a question of how can I as an individual try to affect my private environment. And I have to tell you that it's actually quite difficult as an individual to be able to affect the privacy landscape for yourself and for society. You know, when you get devices, if it's in the United States, a lot of the data collection features and sharing features are defaulted to opt-out, meaning you're already signed in, you're already going to have automatically sharing certain information, and everything's going to be turned on unless you decide to turn it off. This is something that exists within American privacy culture and just in general the American market. And unfortunately, the answer is really to go through the manual of the devices that you get and see what's turned on by default, what's shared by default. And normally, you know, these devices will have a relationship with your smartphone or with an online account. And the fact is you have to go through that, and hopefully these devices will have some sort of manager to be able to help you manage sensors, manage data collection, manage deletion, manage sharing, and it's a lot. It's a lot for individuals to try to manage these things. When they come out of the box and they're automatically ready to share, that's something that makes it very hard for people to be able to manage their privacy. And so this is why I'm a big fan of institutional controls, trying to get to change the culture so that people don't have to dig and have an advanced degree just to understand how to work their Roomba. And so it's a great question that is hard to answer at the individual level, and it's part of why I do these types of discussions, is to encourage folks to understand more of the institutional landscape and to give feedback to companies and to give feedback to their Congress representatives and to give feedback to anybody who's involved in selling them these devices, because it's important for people to raise their concerns, their vulnerabilities, the fact that they feel like they can't operate or can successfully control their information when they're using a device. So thank you for that question. Let's see. So here's a follow-up question from Mary. Doesn't sharing / potential sharing need to be addressed as a usability issue to ensure it's not buried in a terms and condition type statement in the future? Absolutely. The terms and conditions and privacy policies, those are legal documents. Those are documents so that the company has basically performed a legal function to declare certain aspects of its behavior because it's required to or because it's entering into an agreement with you through the terms and conditions. And yes, the way that privacy language is structured within terms and conditions and within privacy policies is very unfriendly to people. Part of the way that that can be addressed is some companies go out of their way to make it easy. Some companies go out of their way to have language that everybody can understand, that this is how we use your data. Some time ago, a company created a graphic novel of how do we use your data so that you could follow along with illustrations because it makes it easier. And so this is a communications issue in the sense of the companies communicating to people, but there also needs to be continual encouragement of companies from an institutional perspective to do better and to be able to notify consumers not only just when you open the box and open up the plastic, but one of the suggestions of the Article 29 Working Party is that periodically a device will let you know, hey, I'm monitoring you. Now, certainly plenty of people are going to say, you know what, I get it, I don't need a light blinking, I don't need a notification, but other people are going to want that. And so there's definitely very good work going on in different parts of the privacy community to address this issue of making it easier for people to understand. And so it's generally under the heading of notice or notice and choice. The choice part is you get to walk away if you don't like what you've been notified of. But essentially the heading is notice. One academic whose work I really like on this is Professor Lori Faith Craner, who has been spending years and years of her professional career on just this problem, on the problem of notice, the problem of how do you get people to understand what these devices are doing. So certainly, terms and conditions and privacy policies as just the way that we notify are a woeful way of getting people to understand what's going on here. So thanks for your question, Mary. I'm going to move on to this one. Let's see. This is a broad question. Thank you, Ronald. How are generational and cultural differences shaping privacy for the IoT? Wow, I can't answer that question in full because the answer to that question, I think, would take years and years of research, lots of different ways of formulating the question and asking people. So I can speak a little bit more, I think, to the cultural side than the generational side. Privacy culture, of course, is different going from country to country because of both the cultures of the people within those countries, but also regulatory culture and legal culture, and the culture of the relationship between people and the market. So there are a number of cultural elements that come into play with privacy, not just with the IoT, but with everything. So, for example, the United States has a terrible, terrible hatred of national ID cards and national identification generally. It's just something that goes back in time, and it's this very strong, powerful cultural element. Other countries, such as Spain and Germany, have national ID cards and, treat them differently, can have, a different relationship with them. And the reasons for that are historic as well as legal culture. And so it's very hard to generalize about this. Instead, there are great ways to look into sort of privacy feelings by looking at research that probes people in different countries. I know that there's some great research that's looked at the UK and privacy attitudes, and in the United States, you have the Pew Internet Project, which has touched on this quite a bit, has looked at the IoT and has looked at if not on the IoT, generally privacy sentiment in the United States, and looks at it across different ages. There's also been great work that's come out of Berkeley, in the University of California, Berkeley, that has looked at differences in privacy attitudes generationally, so 18 to 24s and then 25 to over 65. So there is some research that's out there. It's hard to do. It's a lot of survey work and it's a lot of statistical work, and so for it to be high quality, there's not a huge number of them out there, but there are a few good studies to take a look at. So thank you for that question. Let's see. What happens when someone revokes? This is from, says Meet. What happens when someone revokes the consent to share the data after using a system for some time? What are your views on the data which is already shared? Well, so the first question is a really good one. What happens when someone revokes consent? So this is an Achilles heel in the consent regime that dominates a lot of products and services. There isn't a very good mechanism for the revocation of consent right now. Revocation of consent at this point is tantamount to leaving the service. We don't have yet a lot of very obvious mechanisms to be able to revoke consent but then potentially continue to use a service. A lot of the way that the market works with respect to the use of personal data is a kind of take it or leave it approach. Sometimes that's completely appropriate. There are sometimes when there are products and services that if you don't consent to certain types of data use going back and forth, then they just can't provide the service. And that's reasonable. And so in that case, a revocation of consent does mean leaving the service. However, if you leave the service, that doesn't necessarily mean they're going to delete your information. They have to have promised it to you. And this touches upon the discussion of the right to be forgotten, which is a very, very polarizing and challenging and wonderful debate. And part of that is about the idea of deletion rights. And in this case, I'm arguing that the revocation of consent would be related to that. But to get back to my earlier point about the car, what if you wanted to buy a car that had all these great features that did a bunch of detection inside the car, and then 2 or 3 weeks later you're like, I don't know, this isn't for me. I want to revoke consent for the car to collect information about me. So that is still evolving. That is still an evolving set of conditions as to how that would happen. Would it affect other parts of the system? I argue that with the car is meant to drive. And so if there's collection inside the vehicle, you should be able to not consent and still drive the car, revoke consent and still drive the car. And so it's up to, in this case, car manufacturers, to be able to incorporate that into their systems, because that is respectful of user choice. That is respectful of the idea of consent. Consent means nothing if you can't revoke it. So thanks for that question. Let's see. I'm going to jump to the next one. Are there any standard or helpful resources for contextual privacy adaptation? Well, so contextual privacy is, if we're talking about the idea of contextual integrity and sort of viewing privacy as a much more fluid and context-driven set of information flows, there's a great book by Helen Nissenbaum, who has been working very hard on the theory of contextual integrity, called Privacy. So Helen Nissenbaum, Nissenbaum, has one book out, and that book is a great collection of chapters that explain contextual integrity. There are a number of papers on what's called the Social Science Research Network, SSRN. So if one goes to SSRN and just looks up contextual privacy or contextual integrity, a huge number of papers will come back on that. Also, one might want to look up use regulations, which is related. Let's see. We've got another question here. Isn't there any provision to check for the privacy issues while filing the patent for the product or getting it certified to be able to be marketed? I'm not sure I fully understand this question. Devices when they're coming out, in liberal democracies and in big free markets, devices, unless they live within a regulated environment, like a medical device that you might implant into somebody's body, or devices that are high-power devices, or cars which are regulated. In regulated environments, then there may be some type of regulations relating to privacy for something to go through, although generally regulations around the creation of products are around safety. So I hope that answers your question. Let's see. So Daniel writes, is there any kind of privacy/security certification or industry standard for IoT devices that consumers can look for? That's an excellent question. And so there are a few privacy seals that you see on the net for the web. So in other words, online businesses, e-commerce businesses. So far, there has not been a large appearance of privacy labels or security labels in the IoT world, and that's partly because the Internet of Things is an evolutionary continuation of existing products. So it's hard to sort of go to a store and say, give me an IoT device. That's not how it works. You are starting to see, of course, wearables in stores and fitness devices as a particular section. If you go into, Best Buy or for something like that, you will see there's going to be one row which is something just wearables. But in that case, those types of devices are going to draw upon the previous market history of devices that are similar to them. And if there weren't a lot of security or privacy seals in that case, you probably are not going to see them right now. If you go out and you get a Roomba and you take a look at it, it's going to have the basic marks that says that it doesn't burst into flames, and it's been certified to work in Europe and in the United States. But you're not going to see yet a lot of devices about that, and that's because these issues are still very early. The devices are early. The evolutionary point that we're at technologically is very early, and so are these devices trying to understand what's different, like what's different than the privacy problems we've had before. That's an evolving conversation. That's part of exactly why I'm trying to have these types of discussions with great audience members like you, is to be able to get these ideas out there so that these questions start to come more and more, so that the manufacturers start to ask themselves these questions as well. So I think that has taken me through all of the questions that I believe I can answer. Thank you all so very much for listening, tuning in, and for these great questions. I really appreciate it. And thank you very much, Katie, for hosting, and thank you, O'Reilly, for putting up this webcast.
Well, once again, we'd like to thank you, Gilad, for being with us and for presenting such an outstanding webcast and sharing your knowledge and expertise with our audience. And we'd like to thank all of you that attended our webcast today and hope you've benefited from it. We'd invite you to visit webcast.o'reilly.com and take a look at all of our upcoming events. You can also sign up for our weekly email newsletter, highlights all of our webcasts. The newsletter comes out every Monday. Our events are free, so we hope to see you on an event in the future. Thanks again for joining us. This will conclude our webcast today. Goodbye, everyone.